चिंता की है।
मैडम मैं कॉल करूं मैडम को?
जस्ट मेरी बात हुई, मैडम बोले मैं ट्राई कर रही हूँ, ज्वाइन नहीं कर रही हूँ, हो जाएगा विद इन ए मिनट।
ओके ओके।
आ गया मैडम। मैडम गुड मॉर्निंग, वेलकम। रेखा मैडम, मैडम हैज ज्वाइन।
गुड मॉर्निंग, वेलकम मैम।
दुर्गानी मैडम, प्लीज अनम्यूट योरसेल्फ मैडम।
गुड मॉर्निंग मैम एंड वेलकम।
Yes, I'm actually in Gujarat, so I'm very close to Anand.
Oh,
great.
Yeah, I'm in Navsari.
Oh, very nice,
so,
very nice.
So yeah. So I'm telling Rekha ma'am, હું ગુજરાતમાં જ છું.
ઓ શું વાત છે મેડમ, તો બસ આવી જાઓ મેડમ.
હા, તમે કહેતે તો હું આવી જતે ને.
રેડી મેમ,
એટલે નવસારીમાં તમારા ડાયરેક્ટ ટ્રેન થી બેસે તો આનંદ આવવામાં કઈ 1.5 કલાકનો ટાઈમ લાગે. હું નવસારીમાં છું.
ઓકે ઓકે, ગ્રેટ મેડમ, ગ્રેટ. વેલકમ
ટુ નવસારી. There is a place called Dandi. Dandina પાસે ગામ છે, ત્યાં we have come, you know. My husband's native, so we come there.
रेखा मैडम को प्रीवियसली पता होता तो वो आज आपको वहां पे
वो मुझे
आनंद ने आपका सेशन लेके हमको स्क्रीन पे दिखाते थे।
थोड़ा नहीं होता, मैंने यहीं पे
वो आ भी जाते। हाँ चलो, but next time, yeah.
But welcome to Gujarat.
Yeah, welcome to Gujarat. Yes, but I should say, yeah, thank you very much. But I am half મારા husband નું ગામ છે એટલે અમે આવીએ છે. So thank you for welcoming me. Okay.
Darshana madam, Rekha madam.
Yes.
शुरू करना है? With permission of madam.
Yeah. You can start.
हाँ, yes, please. Comparer. Darshana madam is muted herself. I think she is having network issue, madam.
Yeah, today the morning also some network issues are there.
Start the session. Darshana madam, please unmute yourself first. Good man. Rekha madam, am I audible? Getting voice from Darshana madam?
No, now you're audible.
Now audible. Please continue. And this Pinkal Patel, getting voice. Morning to all. I think Darshana madam is having network issue, so with permission of Durgamini madam, we will start.
Very good morning to everyone.
Yes. Good morning,
a very
everybody.
warm welcome to our distinguished guest and speaker, Dr. Gujarat Patel.
Start with the welcome of
Yes. Thank you, Rekha madam. Very good morning and very pleasant morning to one and all. Respected today's resource person, Professor Dr. Durgambini Patel madam. Madam, we are happy. We are feeling glad to have you with us in today's session, and we are going to learn the research methodology from the learned personality on the research topic. So it's our privilege, and we are feeling very glad to listen, madam. So friends, before moving ahead and before handing over mic to the madam, let us have the brief introduction of Durgambini madam. While I was reading the introduction, I was reading the CV of madam. The very first moment I thought, Wow, what are the things Madam has performed? When we will reach on those heights? So this was my first thought in my mind. Whether we can be there or not, that's we don't know right now. But definitely, after reading Madam's profile, it was pleasure to have the personality amongst us like that. Madam is a wonderful personality in the legal profession in the Maharashtra state. She is a very renowned person, friends. Professor Dr. Durgamini Patel, Madam, uh, is a professor in the Department of Pune University. Presently, it's known as the Savitri Bai Phule Department of Law, Pune University. Madam is having more than 25 years of teaching experience in the area of PG and UG. She has also worked as a law officer in the same university for few years. Madam has completed her BA, LLM, NET, GRF, and PhD. She was a rank holder in the entire classes. Her topic of PhD was application of Article 141 of the Indian Constitution to the labor management relation in India. Madam is a recipient of about 11 different awards in her account. Under the great guidance of Madam, 15 candidates have completed their PhD, and more than six are pursuing. Six are rightly pursuing now. Apart from that, Madam has guided more than 320 candidates of a LLM dissertation. She is also having 2 books in her account, and more than 33 research papers are published.
બેન પેલામાં ના થોડા વાસણ છે તો એ ત્યાં જ ધોઈ કાઢો અને હા પેલામાં જાળીમાં અને એ કચરો એમાં નહીં જવો જોઈએ ખાલી.
Madam is also chief editor and chief editor of different journals and magazines. She is also occupying the member of editorial board in the different panels. She has also done 6 different research projects funded by UGC, Savitri by Phule, Pune University, and different other agencies. More than 200 national seminar and conferences are attained by Madam. Sessions were delivered by Madam, and she has also delivered different keynote addresses. Madam had also participated and presented paper in 25 international conferences organized by different countries in different places. Till today, Madam has visited about 11 different countries for academic training programs and conferences. Madam was also the visiting faculty of Nepal University, and she had also done some special courses from different countries, Spain, different university like USA, different places, and Madam is recognized member of the various academic committees such as US, RAC, Academic Council, etc. Friends, that considering the time limitation, I have to stop myself here by briefing the introduction of Madam. Actually, it's a very vast brief of Madam's. Actually, Madam is having very vast introduction, and her profile is very, very nice and big. So instead of becoming a hurdle between Madam and you, I'll stop myself and I'll welcome again Madam, and I'll hand over the mic to the Madam. Madam, please take over the mic and start your presentation.
Okay, thank you. Thank you for a very nice introduction. Let me tell you that once you come to my age, definitely you will also achieve the heights. Only thing, you have to be like a tortoise, consistently work. So this
keep
comes.
Blessing, ma'am. Keep blessing.
Yeah, yeah.
Thank you.
So by way of time, this happens. So I wish you all a very happy new year, and also I wish you a very bright future, academic future. And as I said, that once you work very devotedly, and it's only hard work it takes you. You may be extremely intelligent, very fluent in English. These things don't work. What in law you require is continuous reading, continuous hard work. This is what our teachers have told us, and we pursued So somewhat I could have done better, but then, well, that's fine. Let me tell you that I have just retired from Savitribai Phule Pune University, a superannuation at the age of 60 in September, planning to join some other institutions. Let's see how it happens. Right now, I'm enjoying my break, sitting at my village in Gujarat. So, friends, good morning. And today I'm going to speak to you about the work, the thing which has been given to me is doctrinal legal research. Yes, what is given to me is doctrinal legal research. And let me tell you, friends, when we speak about doctrinal legal research, I've been told to speak on non-doctrinal legal research. Why I made that mistake about doctrinal legal research? Because a non-doctrinal legal research is a second part of your research. Your first part of your research always needs to be a doctrinal legal research. Let me just give you a brief historical evolution as to how non-doctrinal legal research became really very popular as well as legal research is concerned, and how nowadays non-doctrinal legal research is the in thing. No research project or no grants are given to any projects unless there is the non-doctrinal aspect into it. So non-doctrinal legal research is a very significant and important aspect which comes subsequently to conducting a very solid, robust doctrinal legal research. So do you understand that only after you have had a complete study or a complete research in doctrinal legal research that you should move to non-doctrinal legal research. It is said that if you directly go to non-doctrinal research, you don't know what to examine. You have to know the law, you have to know the case law, you have to know all the doctrinal material as to what reports are there, what committee reports are there, what case law is there, which legislations are there, which subordinate legislations are there. Understand your doctrinal work strongly, understand the complete canvas of doctrinal work, then only you can indulge into non-doctrinal. If you directly jump into non-doctrinal work, you will fail because you would not know what to look. You do not understand what is the impact of law in a given society. You can't understand because you don't know what the law is. So do you understand? So non-doctrinal legal research comes subsequently to conducting all your literature review. Your doctrinal work is over, you have read reports, you have seen the case laws, you have seen the legislations, you have seen the subordinate legislations, you have known the international law, you've known the constitutional law, which is having linkage to the topic, and then you are going to the field to see the why, what, how, and about the law in the society. Now, about law, it is said that law is a normative science. It lays down norms which need to be followed. It's a behavioral science because it regulates behaviors. Okay, it's and it's a prescriptive science because it prescribes what kind of a behavior you should have when you are in a domestic field, when you are on the road, when you are in public, what kind of behavior is said to be appropriate behavior and which is said to be inappropriate behavior. There would be a sanction if you behave in that manner, and you will be governed or you will be punished as per the law. So it is called as a behavioral science, it is called as a prescriptive science, it is called as a normative science, and of all, it is a social science. Do you understand? So social science per se, it's a part of humanities and social science. The reason is because law does not fall from the sky. Law operates in a given society. So perfect universality of law is not there. What laws are there in India may not exactly be there in some other country. Of course, some common things will be theft is considered as a legal wrong in all legal systems. But every legal system, depending upon the social ethos, the culture, would have specific type of laws. So the law takes its color from the social ethos, the political ethos. Now we are living in a country with secular, a secular system with a constitution governing. It is not a theocratic society. So there are factors which influence law. So the lawmaking is a process which takes its color from what is the need of the society. Now, why Dowry Prohibition Act was? Because that was a menace, that was an evil which was prevailing. Maybe perhaps if you go to Germany, they may not require similar law because they do not have the practice of dowry, and so that is not a cultural evil which is not prevailing. So law, perfect universality may not be there, like pure sciences. In pure sciences like chemistry and physics, in whichever part you are, the results would be the same. But law lacks this kind of universality. Law takes its color from the cultural needs, the political system, the social system, culture, tradition. All these have influence, and we can, in a country which is governed by a written constitution like India, constitution is the grand norm. So we want all laws can never be ultra virus of the constitutional law. So lawmaking is that kind of process. So when any law is made, it is made with an objective, isn't it? So in non-doctrinal legal research, after studying the doctrinal part of it, you are going to the field, you are going to the society, you are trying to empirically examine. This is called as empiricism. You are trying to see that how the law actually operates, because law in books and law in action, there is a lot of difference. The book may say perfect equality, no exploitation. You will have Article 21, you will have Article 19, you will have Article 14, but the reality may not always be the same. Okay. So a legal researcher, after conducting a robust doctrinal work, he takes that law in his hand. In the sense, I don't mean taking in hand means exploiting it, but he understands the law, and then he goes in the field and he tries to see whether what the book says is the same thing in the action. And there you will find that there is a lot of difference between law in books and law in action. So while studying law in action, he uses his non-doctrinal skills to examine why the law is not the same as what it purports to be, and what are those hurdles. Just a minute. What are those hurdles, or what are those impediments, or what are those basically hurdles that are causing the law not to perform. So in empirical research, which is also called as non-doctrinal research, the word empirical comes from the word empiricism, to examine the fact as it occurs in a given society. So you take the law and go to, now for example, take a law called RERA, which came for construction. So you are understanding the provisions of the RERA Act, understanding what kind of new duties it has imposed on the builders, what are the rights does it confer upon the beneficiaries, what kind of duties it is imposing on the on people. So, and then you go to the field and you try to see whether this law, which is regarding construction industry, whether this law, just a minute, hey, I'm Barno. Just a minute, there is a little disturbance. So whether the law is operating as it is expect it to be. So that you try to see in the empirical research. Word coming from empiricism, because the laboratory of law is the society. Okay, like a chemist, in physics and chemistry, they have their own labs. Our lab is the society, because the law operates in a society. So you go to the society and you examine, you talk, you speak to the stakeholders, you speak to the beneficiaries, you speak to the targets. You know, there are two people which with law is concerned. One are the beneficiaries, who due to the law get certain benefits, they get certain rights, and there are the targets who are under duty to perform certain activities, and therefore they are targeted by law that you need to do this. And so law is nothing but distribution of rights and duties, isn't it? I hope you remember the Hoffield's theory of right, duty, and all those four correlatives, and I would not go into it. But basically, why we study that? Because law does, if it is giving privilege to somebody, then that means those people are, they enjoy certain immunities. If there is somebody who is having right, there is a correspondence duty. So remember the Hoffield theory, isn't it? So that is what the law does. So that's why once understanding that there has come into existence a new law, or a law which you want to see the operative aspect of it, the functional aspect of the law, you go to the field and you try to examine that what are the benefits, to whom the benefits have been given. The benefits may be in terms of rights or in terms of power. If it's an authority power, if it is individuals, their rights, whether the rights are, then you are trying to examine whether the rights are exercised properly or not. So whether the rights are administered appropriately or not, because rights can be misused, then that can also be the study. That a law gives a right, but the rights are or it gives certain powers, but those powers are misused. So understanding the feasance, malfeasance, and non-feasance. Okay, so you have a right and you're not exercising that right. That is also wrong. You're having a right and you're exercising in a malified way. That is also wrong. So you have to exercise administrative law. You have to exercise the right appropriately. So that you go to field and see that the laws in the book sounds very rosy, very nice, but the practical life is not like that. In practice, the situation will be altogether different. And that is why in Indian situation, you find that it takes a long time for a law to be the reality. Then in empirical research, in non-doctrinal research, by using the tools of non-doctrinal research, such as by making observations, participatory, non-participatory, by framing questionnaires, circulating questionnaires, collecting data through questionnaires, mailed questionnaire, emailed questionnaires, different types of questionnaires, we'll not go into it, or by conducting interviews are also different type, you find a schedule, use a schedule, or you use in interview which is structured and unstructured interview. These are the tools of collecting empirical data. Okay, you have, because you are going to the field and you want to collect information. You want to ask if it is a construction, a law relating to construction workers, you want to go on a construction field and want to see whether the equal pay law is applied appropriately or not, whether there are social securities which are given to, whether health and safety measures are there or not. You're practically going there on the field, and by collecting data, you're trying to collect information whether the law which is there in the books which talks about social security to construction workers and various kinds of health and safety measures, whether they are appropriately followed or not. So then you collect the data from the field. And as I said, in non-doctrinal legal research, which is also called as empirical research, which is also called as socio-legal research. So in this research, you go to the field and try to collect information by using these various tools of data collection. You collect the data and you bring the data to your table. You understand, you analyze the data, you process the data, you interpret the data, and therefore how you use your tool is also very, very important. You have to use the tools in a very skillful manner, isn't it? You have to put appropriate questions so that you get appropriate required type of data. And so framing of your questions, framing of your interview, framing of your observation has to be focused towards collecting the appropriate nature of data which you want to collect. So you collect that data, you bring it to your table and you sit with the data, you analyze that data, you process that data. Processing also is a very important aspect, like what is relevant, what is not relevant, to what extent it is relevant, whether it is something which is trivial, which can be ignored, which is most essential. So you're processing the data. After you process the data, very finely categorize them, systematically analyze them, then you interpret the data, and after interpreting the data, you come out with your findings on the data. Okay, so all that is a very systematic scientific process. You may have to use how you use these tools of data collection and how do you really arrive at your findings must be very scientifically done, supported by proper procedure, because you can't be governed by whims and fancies. It should be reasoned out appropriately. You have to be very pragmatic, very objective, very scientific. You just can't be governed by your whims and fancies. I feel so. No, you can't feel so. If you feel so, why you feel so? What is that you substantiate because you feel so? So without substantiating, without giving a reason as to why you're arriving at a certain reasoning, it is inappropriate for you to arrive at certain conclusions. Okay, so this is how you have to understand that data processing is a process. Okay, so by using these tools. Now let me tell you briefly that non-doctrinal research is comparatively more recent than the doctrinal one. I'm not saying that any one is less important. Both doctrinal and non-doctrinal research, both are what you can say, both are like a wheel of a chariot, you know. So both are supportive to each other. Okay, both are supplementary and complementary to each other. Without a non-doctrinal legal research, doctrinal research is incomplete because it does not tell you the law, its operative, its functional, its reality aspect. And without doctrinal legal research, it is just like a picnic, you know. You are just going to the field without knowing what you have to look in light of the law. Okay, best example I can give you is, suppose you are taking your students for a visit of prison. Don't you acquaint them that there are certain like prisoners' rights are there, prison law is there, prison manual is there. Prison manual talks about what kind of benefits, what kind of facilities would be given to them in prison, how prisoners' rights are human rights, what rights they have, how does it prescribe for going on parole, what is the right of parole, who are under trials, what do you mean by, I mean, how do a person go from a closed prison to an open prison? You have to completely acquaint your students with all those aspects, which all the legal aspects with reference to a prison. That may be the Prisoners Act, that may be the constitutional law which gives certain rights to the prisoners, Article 21, 22. It also will talk about probation. It will also talk about parole, then prison manual, and all those. Prison manual tells how, what are the, when food is to be given and how it is to be given, how they may have right to have access to their family, what is the procedure. So you acquaint them with all these legal aspect that govern a prison system, and then you take them to the prison, and then you tell them, yes, now when you interact with the administrators, you have to ask them these questions, that how many people go on parole. Unless you know what is a parole, you will not know what questions to put. Okay, so we'll ask that, what do you follow any systematic manual or systematic register is there, where you keep a record of how many have applied for parole and how many is given for parole, when parole is rejected, what is the disciplinary actions do you take in case of any misconduct of an inmate. Is there a segregation between the under trials and the convicts? Are the under trials given opportunity? Because legal aid law says that under trials must be given legal aid so that they can apply for bail, because bail is basically, under our criminal jurisprudence, a matter of right, isn't it? They should be able to. There are many under trials who are languishing just because they don't have money to appoint a lawyer. And so, but the Legal Aid Act says that in case of persons who cannot, it is the authority to provide them some legal aid if required to the inmates, and to see why they are languishing. Is that record properly done or not? So there are a number of legal aspects which you have to go and see. What are the medical facilities? So unless you acquaint your students with the doctrinal literature, your non-doctrinal visit would be futile, would be a waste. It will be just like that you went as a picnic and you saw, the jail aise dikhta hai, waise dikhta hai. That's not. You're not going there as a picnic. You're going to find the actual the functional aspect of the law which is there or not. It may say that they should be given, the prisoner should be given wages for the work which they do. So you will ask them that, can we just see that how many people work and what kind of wages they are given, and is this wage given to them to spend during their stay in the prison, or do you give them afterwards? There are so many questions you have to ask. So this is what I'm trying to say, that don't be under impression that non-doctrinal is by itself an isolated kind of a standalone kind of a process. No, it is an extension of a doctrinal work. So even in your research, whether it's your dissertation or it is your PhD work, see to it that your non-doctrinal work, your doctrinal work is substantially completed. You know at least what to look in, because sometimes there would be a small subordinate legislation. Okay, even in case of environmental law, there would be a number of subordinate legislations. And when you go to field, that you should be reminded, oh, there is a subordinate legislation which asks you to take a feedback of the people living in the doing farming at a particular place, to see whether their water or soil is contaminated or not. So feedbacks have to be taken, because a provision, a subordinate legislation, a rule may say so. Then you have to really see whether the rule is also followed or not. So I'm not talking only about the Parent Act. I'm also talking about your empirical research should be focused in trying to see the working of not only the Parent Act, but also subordinate legislation. Apart from your constitutional law, your international law. Okay, constitutional law is inevitable. Even in an international law, when you are trying to understand the implication of an international law in the Indian soil, in the Indian legal system, you have to see from the point of view of Article 253 of the Constitution, whether India has been a signatory to a particular convention which imposes a duty upon the state to do certain to take certain steps in further of that. So remember Vishaka's case. What was said in that, that since we had signed the CEDAW convention, it was an obligation. We were signatory to it. We had ratified it. We are signatory to it, and therefore the duty fell on the state to make law for preventing sexual harassment at workplace, isn't it? So you have to see from that international law. We are not. Monism, we are dualistic, that needs to be adopted as per 253. So once it is adopted, then you can also, as a researcher, look into whether it is been followed or it has been followed or not. And sometimes you also see comparative literature. If so, comparative literature comes when you want to say that some other legal system is having a better system. Now, when you are trying to do comparative literature, it is not possible for you to go to that country and collect data from the field. It is little cumbersome. You can't just go to, suppose I am following Australian legal system and their empirical, how it functions. I just can't go there and collect data. Sometimes they do, especially when it is international law and all that. If you want to study space laws, and then you see other legal systems which have a very progressive space laws, and go to their, speak to their authorities and ask them questions like, but it may generally not happen. So in that situation, you may rely on secondary data. Okay. In non-doctrinal research, in empirical research, there are two types of data. One is the primary data, and the other is secondary data. Primary data is a data which you go to the field and collect. Okay, because by using the various tools, you go to the field and collect. And secondary data is a data where there is an already existing statistical information, and you are relying on that. So that also is possible. Many a times it happens, like if you want to collect data as to how many FIRs are filed on a particular crime in a particular region, it is impossible for you to collect to generate a primary data, because you can't have that. So in that situation, you rely on a reliable secondary data, a data which is created by the government, which government has the data, and you rely on the statistical information data which is already there with certain governmental, non-governmental agencies who have had the access to collect that kind of information. So let me tell you, many a times. Now, for example, I remember writing long back, that was much earlier, in some 10, 15 years back, on international adoptions, the adoptions which are given to people, children who are given in adoption outside India. So CARA is one of the agency which looks into it. So I can't generate that data because I have no information how many this thing is going from which state, how many children are given in international adoptions. I have to rely on certain agencies who have that record. So I rely on this agency. I ask them, of course, how you collect that data would be you approach that authority, you tell them your requirements. Of course, nowadays people say that you can collect information through RTI, but I feel that RTI should sometimes even through RTI, but if you can approach the authorities, tell them the genuine reason why you're collecting that, and they will give you that kind of data. Okay, so non-doctrinal data many a times is not possible for you to go to the field and collect yourself, because it is not possible. You have to rely on a secondary data, and when you are relying on a secondary data, rely on a data which is, it should be very, very reliable. So governmental or non-governmental agencies who have that kind of an access, and who keep that in record. So many a time, various ministry websites, various agencies, governmental, non-governmental agencies have lot of data which you can get to get certainly, and especially quantitative data, statistical quantitative data, you can collect from that. Okay, so that there can be reliable or rely on secondary data. And when you're relying on secondary data, you can put a footnote and say, justify as to why you're relying on secondary data and why you're not made an attempt to generate a primary data. Because you may have many reasons. It may be a quantitative analysis. You just want to make a quantification that how many this, and that is why you have on relied on a secondary data. So this is how you will rely on a secondary data. So now let me tell you that if you look at jurisprudence, legal theory, at what point of time this doctrinal legal research really became very popular, and as on today, there any research has to be a fine combination of both doctrinal and non-doctrinal. Both, nothing is less important. Both are, as I said, supportive to each other. They are concurrent. They are complementary and supplementary to each other. Now, if you look the legal theory, when historical school, natural law school, when they were there, historical school like Savigny, they felt law is not made, it is found. Okay, but that theory is not so. This thing, law is made, isn't it? And especially in a country with a written constitution and rule of law, law is made. We don't rely. We are not a theocratic state that we really rely only on interpretation of what the traditional law is and govern. No, we are making changes also in the traditional law, where we feel that they are not in tune with the constitutional ethos. Okay. So then came the analytical school, which spoke about the command of the sovereign, isn't it? So they were not concerned about they were called themselves, and even Kelsen, he thought pure theory of law, and they didn't want law to be having any connection or any this thing. It was not at all. They were not. They felt that was an era of what do you say? They were completely confined to a discipline, that is the law. They were not understanding the interdisciplinary or the transdisciplinary or the multidisciplinary aspect of law. They confined themselves to a discipline, and that's why they said law purity. And Kelsen also said that it's just the command of the sun law, and they did not understand this extension, that empirical aspect. But eventually, with after the Second World War, when there was so much of calamity, disasters, law was not able to understand all that had gone after the First and the Second World War, and after the Nuremberg trial, or whatever the Nazis rule and the law. It was felt that if the command of the sovereign is there, and what if the command of the sovereign is not in tune with humanity, is absurd, is exploitative, is a threat to the mankind themselves. And this all put a question, and that is why you will find immediately post Second World War, in 1948 we started speaking about human rights and so on and so forth, and then law has an aspect. It has to be ethical, it has to be morally right, it has to be ethically right, it should do justice, something which it cannot do justice. So law has to fulfill many other aspects, and it was the contribution of Roscoe Pond and the others in the sociological jurisprudence or in the functional jurisprudence, patent and all of them, who have who contributed to trying to look law beyond a particular discipline, you know. And that's why in sociological jurisprudence, Roscoe did say that law needs to be continuously audited. And he said that is social audit of the law, whether the law is fulfilling the purpose for which it is been made, and that you have to examine. And that he said of social audit of law. These are the words which is used by Roscoe. You can read from a simple book like Dias. Of course, you can read from Patent and Lloyd and all that. But if you read even then, he speaks about the 8 points. He says social audit of law. How would you conduct the social audit of law? By using the non-doctrinal legal research methodology. Because you can't conduct a social audit of law as to what the law is doing, what function it is fulfilling. It is also called as a functional school of law. You can't know that until and unless you examine the law in the light of the social reality as to what it is functioning, what it is doing, if it is not doing, why it is not doing, how you can better. What is the work of the researcher? It's not only to find problems, but give solution to the problems. Okay. So in non-doctrinal research, you try to identify the problems, why the law is a failure, why the law is inadequate to perform the kind of activity which it's supposed to do, and then you try to examine the social reality from the point of view of what is the social, political, economical, ethical, moral, conventional. There may be many countercurrents to law. There may be a tradition, particular traditional aspect which may be influencing a particular behavior. It may be also an economical aspect. It may be economical empowerment is required, or social, political, whatever it may be. So a researcher tries to identify all these kind of interdisciplinary aspects of law. What is the anthropological? What is the historical? Can you understand when you study Article 14? You have to look into the historical aspect as to how the system of came into this thing, why there were these kind of multiple inequalities, which were there, competing in, Mark Galanter's book, competing in inequalities in the country, so you have to look into his historical act. When you're studying 16, you're studying 14, when you're studying 21, you can't understand constitution unless you see what really motivated the makers of the constitution to insert particular provisions like 17, 18, 16. This has an historical nexus. You can't be monodisciplinary. In non-doctrinal, you enter into other disciplines and try to see what is the economical implications, what is the political implications, what is the social implications, what is the conventional, in the sense tradition, culture, custom, also act as hinder in making a success of the law. So after seeing the non-doctrinal law, you try to understand why that law is not achieving what it wants. So you try to see the countercurrents to the law. And there you have to take help of going into interdisciplinary inquiries from the economical field, from the political field. Certain things cannot be understood unless you understand the political ethos. That political system is such, and it's not only in India, but in every country, law, what twist and turn it takes would depend upon the socio, political, economical, cultural, traditional ethos that prevails at that time in that place. Okay, at that time in that place. And that is why it is said that from time to time, from place to place. Okay, today in India and 15 years or 20 years back in India. So today we have moved to much more a different kind of a society which was there, say 50 years back. You know, I come from an institute where I studied is more than 150 years, more than 100 years old institute called a Ferguson College, which is a very old college in Pune, which started somewhere in 1875 or something, long, very old college. It seems that time, in the first few years, there were no women in the college, but then slowly women started coming. So there is an ethos, you know? So and then why women's education was not there? Why you need to have protective discrimination laws to protect the disadvantaged categories like women or the weaker sections of the society, which is based on caste. So disadvantaged class. Why? Because it's an historical aspect. Okay, so while conducting a non-doctrinal inquiry, you go into interdisciplinary approaches, which is very important. It is not merely sociological, it can also be psychological, sociological, political, anthropological, okay, and definitely culture and all that comes into this thing. Why I'm saying economic also is very important, you know, because as far as right is concerned, they say that having a right is not important, but more important is to have the power to exercise the right. You may give right through a law to many disadvantaged category or underprivileged, but if they are not empowered to exercise the right remains in abeyance. They can't. So by conferring rights through law, do you achieve the reality? You don't. You have to empower them, and that is why we have this concept of empowerment in law. You know, you need to be empowered to exercise that right. Okay, and that may require political support, economic support, many other awareness, and a system where you encourage people to exercise that right. And that is more important. For me, sitting in parliament, making a law that these are your rights is very simple. I'm not saying it's simple, but let me tell you. But actually bringing that law and let the law percolate down to the grassroots levels for whom it is made is much tougher than making the law. And that is why whether it is environmental law, whether it is property laws, there is, you may find lot of dichotomies. There is so much of dichotomy. You know, even in case of environmental law, India is supposed to have the best environmental laws. However, if you see in reality, there's so much of use of plastic. How much have you ever noticed? I many a times feel guilty, but I can't do anything because each household generates how much of plastic which is given across. You go to buy anything, you generate so much of use of plastic. Though there are provisions under environmental law regarding plastic and even disposals and all that, you know, biomedical waste and disposal of disposal of the e-waste. E-waste management is a whole concept, but the reality is very different in India, especially, you know. But if you see certain countries, we are very rigid, very strongly implement. You can't throw your batteries into the garbage. If you have used batteries, you have to store them, and they will have a different process to process that kind of a waste. Okay, we have, whether you take environmental law, you take family law, women in law, children in law, you have so many things, but still you will find many children out of school. You know, we have had such a big agenda, policies, and let me tell you, yes, with policy, let me remind you that when you are doing empirical rigor research, you are also required to indulge into the policies which are framed by the authorities to implement the law, because you are trying to see the implementation of the law, whether it is appropriate or not in non-doctrinal research. And quite a few laws required a robust policy to be framed to implement the law. So you indulge into that also. Whether there are appropriate environmental policies in place, whether there are appropriate policies with reference to education of children, and you still find, go to remote places, you still find child labor, you still find child marriage, you still find children out of the school. Now your job as a non-doctrinal research is to understand why such situation is there, and through your research, you are supposed to give solution how to make a law a reality. There is a maxim called UB just EB remedium. Where there is a right, there is a remedy. You as a researcher should give a remedy in empirical legal research that this is the law, these are the people who have the right, however, they are much away from their right, and therefore this procedure needs to be adopted by which the law can be a reality. So the work of a non-doctrinal legal research is to suggest appropriate solution to make the law a reality by trying to find out what are the hurdles, what are the shortcomings, why there is a failure, how to overcome the failure, what changes in the law needs to be made, what appropriate policies need to be framed, what necessary actions need to be taken for making the law a reality, because making a law and implementing a law are two different things. For implementation, you need certain steps to be taken. You need to educate people, you need to create awareness, you need to empower them, you need to have protective discrimination measures, so that you and you also give certain incentives that yes, if a girl graduates in a particular household, there is a incentive given that she is not married before graduation, but her graduation is over. So some incentives need to be given. Certain measures have to be adopted to make the law reality. So the work of a non-doctrinal researcher is to find suitable solutions to make the law a reality, to give suggestions for the effective implementation of the law by finding out what are the hurdles and how these hurdles can be overcome. There are n number of reasons. One of the very common reason is poverty poverty, lack of awareness, lack of internalization. Then you have to create that kind of a situation. Law, and that is why law needs to percolate down in the grassroots level, needs to take help of certain agencies, maybe non-governmental agencies, or certain policy schemes need to be there, programs need to be there, schemes, programs, and policies need to be framed. Now, take an example of the Article 21A, right of children to education. Then you had the 2009 Act, that is the Right to Education Act. It has some different name, but Right to Education Act, Children Compulsory Education Act. But merely having a provision in as 21A in the Constitution, then having a legislation is not sufficient. Then they have to have an abhiyan, that is Sarva Shiksha Abhiyan, where it is a policy or a framework where you are trying to take this statutory law to the grassroots levels. So you need to have certain schemes, programs, policies to make the law a reality. Only having a very beautifully drafted constitution and a very robust legislation does not make the law a reality. There is lot of gap between the law and the law in books and law in action. So to bring the law into an action, you need to have all these aspects taken into consideration, and that needs to be that needs to be understood. Okay, and you have to give appropriate suggestions. I think somebody's mic is on, so that is Darshana Acharya. Please switch off your mic.
Darshana, madam, please
Darshana.
mute yourself.
Darshana, mute yourself. So, do you understand? In a non-doctrinal research, just don't find faults. Finding fault is a primary thing, but after finding a fault, look into the law, look into the policies, look into the rules, look into the schemes, suggest robust solutions as to how the law can be a reality. And that is the contribution of the researcher in a non-doctrinal research, where he says that, look, it is because of economic economic deficiency, or lack of education, which is not a lack of economic capacity, that a person is not able to exercise that right. Then you have a policy, or have a scheme, have a program where you can identify those vulnerables who are beneficiaries under particular, identify those and bring them in the mainstream. What can be done to do so? Now let me tell you, uh, with the contribution of Roscoe Pond and his followers in the sociological and functional school of law, and also recently there is another school of law which is called as the critical legal thought, or critical legal school. It sometimes they say it's not a school, it's a thought, whatever it is, which have also recently, because they look into the critical aspect, because having the law, they say that at the end of the day every law is politics, and therefore unless there is a political motive, no law can be a reality. Okay, so unless there is a social like there is a writer called Julia Stone who says, who has written a book on the sociology of law, or the social aspect of law. They are saying that law and reality is different. Unless you, if society supports, if social ethos is there, the law becomes a reality. And perhaps you would not require the law if the society is in tune with the need of the law. You will not need to use law to implement, because social ethos is in tune with the requirement what the law wants. So, but what happens in, especially in a country like India, we will find there is lot of diversion between the law and the social ethos, and therefore you need to conduct non-doctrinal legal research and take proper actions. Now let me tell you, in legal education there is a concept called clinical legal education. Of course you have legal aid also, where you have this in UG, you train the students to give legal aid, and then you identify people who cannot have access to the law, and you provide them legal aid. This is a kind of a training, learning come training process, where you teach them how to exercise legal aid to those who cannot have an access to it. There's a concept called clinical legal education also. I think you may have this in your, you may be having this in your curriculum. But this clinical legal education is also one of a very important aspect, which tells you to go to the field and to be like law is like to run a clinic in the society, so as to do the therapy for where the law is not properly implemented. Law is like a therapy only. It's like when you have a stomach ache, you take a medicine. But when you have a exploitation, you use a law to remove that exploitation. When you have injustice, which is happening, you use the law so that justice is been done. So in this way, through this clinical legal education, also you take the students to the field, You can read the book. There is a book, maybe your library may be having, by Madhava Menon on clinical legal research. This is an outcome of to exactly how to execute non-doctrinal research, taking your students to the field, telling them, yeah, they're here, they have this kind of pollution problem, but they are not able to. They are not able to have proper access to drinking water. They are not able to have proper access to various aspects which they are supposed to have. Then you enable them, you make them aware of the law, and you act as a therapist, and see to it that the community who is deprived of its rights, how they will be enjoying those rights. And that's way you train the students. This is also to create what do you say, to create a social connectivity, or to create social awareness among the because this is called also as a social outreach, because social outreach has to be, law is not to operate in vacuum, it has to operate in a society, isn't it? So social outreach has to be there, and that can be achieved through a robust scheme of non-doctrinal research, where you go to the field, you ask all different stakeholders, make it a point that there would be a number of stakeholders in with concern with law. Now, for example, if it is a RERA Act, then you have to speak to the builders, to the consumers, to the workforce. So there are so many stakeholders. In a law, there would be more than one people who will be concerned with the laws. There would be beneficiaries, there would be targets, there would be what do you say? There would be those who are having certain duties and certain responsibility. So law is an instrument of social change, isn't it? Okay. And if that change has to occur, it is a necessary to see how to bring that social change through law. And for that, you need to conduct a field research, understand what changes need to be done, how the society needs to fall in tune with the law, what reasonable solutions can be there within the framework of law. So that can be seen. I'll quickly run through one PPT which I just want to show to you. Your entire screen, yeah. This is already there. This is already there on the. Can you see this screen? Yeah.
No, ma'am. We are not able to see.
Okay. Share. Share. Maybe the internet is not supporting.
If you will share me through WhatsApp, I will share it to my side.
Abhi WhatsApp pe lene ke liye it's difficult for me.
Okay.
Because
No worries. Or
no, but this is not. This is some information which I have taken from the internet only. So I can just tell you certain aspects of it. Right? Justice Holmes, he had said, for the rational study of law, the black letter may be the man of the present, but the man of the future is the man of statistics and master of economics. Did you get me? So it is not merely the black letter of law. Many of these who supported empirical research, they said black letter is the legislation which is there in the statute. Is saying black letter is not the only thing. You have to see the future of law, which is there in statistics, economics, sociology. So in this non-doctrinal research, you are using these multidisciplinary approaches. You're saying eco-legal studies, socio-legal studies, psycho-legal studies. Psycho-legal study is also very important. If you are a student of criminology, you will understand how psychology plays a very important aspect with reference to cause of crime. Okay, so psycho-legal study, which is very, very important. So, and that is why uh, post Second World War, when the US went into a very economic depression, President Roosevelt, the law schools over there uh, evolved that kind of a the law schools over there evolved a kind of a movement. You know, it was a movement that happened in 1930s to 40s, where the realist movement also influenced making an empirical investigation into the law and its performance in a given society. Okay, so empirical law movement started in United States. The law schools, very robust law schools, they said we are not just to teach the black letters, but we also have to get into that the capacity of the black letters to really trans transmit or transpire or into the reality, which was not there, because law talked about so many things such as equality, violations, exploitations. But the Second World War showed them that the situation is so worse that all these concepts had no meaning in reality, and therefore empirical work took in forefront, and they said law must have an interface with social sciences. And that was the kind of a movement with sociological, as I said, Roscoe Pond, and also the realist movement. They realist also, if you study, they really want to see that what law is not what it says in the black letters, but who is interpreting it, who is implementing it. So the role of the judge, the role of the executors, that is the administrators, that is also very, very important. And this movement tried to highlight the difference between law in books and law in action. This movement in US, which came in 1930, especially the contribution in, if you see, the sociological and the realist with reference to law in books and law in action. So, concern of law. Now, understanding the sociology of law, why the law is there, why particular laws are there. You have a very particular type of law in every legal system, isn't it? So there has some sociological perspective to it, why that law needed to be there, why all of us, all the countries have environment law. There's a social aspect, and that is nothing but climate change and so on and so forth. So and is in and take laws pertaining to women's empowerment. Why these laws are there? Because the social aspect was of a derogative type, and that is why you needed to have these kind of law. So this is how this interdisciplinary approach helps you to make an interrogation into the informal legal, into the formal law, and taking and understanding the empirical aspect of it. You know, there are many good books when it comes. You have an handbook on empirical legal research. You also have, there is a handbook you can see. It gives a complete, it's a huge voluminous kind of a book which you can see. Then there is Journal of Empirical Legal Studies, which is there, which you can look into. Then you have lot many journals in law schools around the world who look into this empirical aspect. In fact, even today, like, you know, if you want to contribute for an international journal, write an article, they ask you to incorporate some empirical aspect, maybe not primary data, but at least secondary data. But they just don't want stories told of the black letter of the law, which anybody can read, but you have to go beyond the black letters and see the functional aspect of law, which you may go for collecting certain data that empirical data, which may be either by your own collection or even the secondary data can be there. So now if you find quite a few well-established journals in law established these laws, the journals, even articles, I'm not saying books, even articles running into 7,000 words will have some kind of an empirical perspective to their research paper. And this is the need of the day. Let me also tell you, from 1930s to now in 2021, there is also another aspect. Anything which is extreme is inappropriate, isn't it? So there is another aspect of it. Lately, you will find also literature where they say that too much interdisciplinary and ignoring your discipline is also wrong. Because it was found, there was some school in this, they lately found that there is so much of devotion towards empirical research, or so much of devotion towards interdisciplinary research. In this whole perspective, we are forgetting our own discipline. So that also is not appropriate. So I wanted to make you aware that when you go to another discipline, like you are studying the law, then you are studying the social aspect of that law, but come back to the law. And therefore, I have suggested that come back to the law and make suggestions into the black letters of the law, or the procedural law, or the after substantive law, the procedural law, the policies. So it is inappropriate that you, many a times in many of the research proposals, we have to say that what is the law? You're only talking about the sociology. You're only talking about the socialized. There doesn't seem to be in the title or in the content anything where, as to how you're interrogating into the law. So once you study the law, go to other disciplines, make an empirical research, come back to your own discipline, because primarily your research is not in sociology or in economics or in politics, but in law. So ultimately you should come back to your law. Your major coverage must be to the law, and it should look, because there are many studies which can be simultaneously done in other this thing also. With GST, for example, even the economists, they study into GST. But when we study into GST, we study from a very different perspective, from constitutional perspective, as how we will see what influence it is having on center-state relation, how it is, whether how it is affecting the federal structure, how it should be there, whether we are in tune with the constitutional framework where federalism. Oh,